and maybe if you have any questions up front, then maybe send some of the information that I was going to present to answer your questions, and just kind of keep it informal and get as much information out to you as we possibly can that you might be interested in. So I'm open to a dialogue regarding whatever you wish to discuss related to mediation and guardianship. So that's one. The other, we think that Monica has been participating or attended some of our other workshops or presentations. And so well, it looks like we have two Monicas up there. Which one is it? Okay. Anyway, let me quickly tell you what the situation is here. We're in Lubbock, and we're rather unique, and there's nobody else is structured the way we are in the state. And, let me just kind of give you some background so you know where I'm going with all this. But the Lubbock operation, we're Department of the Courts in Lubbock County. And we've existed for almost 30 years, but in 2003, the Board of Judges decided that they wanted to have the department accountable to them. And consequently, we became a department, and I became an appointee of the Board of Judges and accountable to them regarding all of our activities. And we meet monthly and go over whatever it might be. We've been providing a range of services. Lubbock is set up differently than any of the other counties in the state. Everybody does have mediation today. It has some form of mediation requirement. The cases, both civil and family, go to mediation. But what Lubbock did a little bit differently is that actually put 2 mediation dates on all the scheduling orders, that you can go private, let's say hypothetically by September 1. But if you don't go to a private mediator by September 1, then the expectation is that on September 2nd, you will appear for your scheduled mediation in this office. Thus, we touch basically every single civil and family case that comes through the court structures in Lubbock. Unlike most of the other communities, we also receive every single civil case filed in the justice courts, JP courts, and thus we have that activity ongoing throughout the day. And so everybody's got time slots, and we have mediators. We have approximately 70 or so mediators. Mediators in this county, and I'm just trying to give you the background. Terry knows all this, but I think Monica does too, but it's a little bit different. Mediators who work or are affiliated with this office are not volunteers, they are paid. And so mediators here, if you have a civil case, you will receive approximately $200 an hour, $100 per side. Family case is going to be less, but it's going to be, if you're an attorney, $50 per side. So all of our cases are not going to be cheap, so to speak, but we do compensate the mediators. We do not operate on a volunteer base. And so thus we don't have a bunch of people coming through just to get some experience. Our idea is that we're going to have a core of mediators on a regular basis. And again, I'm making maybe some bragging here, but this office also mediates criminal cases. We receive referrals from the district attorney's office and the city prosecutors. So we'll have that batch of cases coming through here too. And then sprinkled in there, we'll have the guardianship. Guardianship, it normally is going to be coming from, in our case, the county court of law, or maybe an estate matter. But we've got a full range of cases. We now have at Lubbock the capacity to have 7 concurrent mediation sessions because of the virtual aspect. And so every room that we have is set up to conduct a virtual mediation. And sometimes that's what we've got going on. But that's our background here, and it is a little bit different. And I know San Antonio, I've been talking to them about trying to get some things started, and some of the other communities, they want to pick up on what we're doing. But X number of years ago, we built a relationship with Texas Guardianship Association and Terry Hammond, and we decided we'd start offering the guardianship mediation training. And so we began with 24-hour training session here, the first one in Lubbock, and ended up with a small group, I believe 8 or 9 people, if that's correct, Terry, if you remember. And so we've kind of built on that. The number, as most of you know, the number of guardianship cases, new filings, is not that big. And so one of the things I was going to talk about today or mention was, what can we do to utilize mediation in different stages of the mediation of the guardianship process, with annual reports or whatever it might be, items that need to be considered or issues that maybe come up during the course of a guardianship. We've also mediated guardianship cases related to children, and those are different kinds of things there. So I wanted to provide that background, given that we're not going to have formal presentation, to see if anybody has any particular questions that you want us to go in a particular direction, or want me to jump up and shut up, or what do you want me to do? Anybody have any comments, questions real quick? Yes, Monica, go ahead.
Hi, so I'm Monica. I am a 17-year attorney in Fort Worth, but I just got my mediation certificate as of about a month ago. It's something that I'm really interested in making a regular part of my practice, but I don't know where to go from here. I don't know if it would be better to go ahead and take the guardianship training. I'm interested in primarily probate and guardianship mediation. That's my area of expertise. So I don't know if it would be a good idea to go ahead and get the extra training, or to kind of cut my teeth on, some smaller cases. So that's question one. And then question two is, where do I go to get that experience? If you have any suggestions. Dispute resolution services in Tarrant County is closed. So there's no central place that I know of to be able to get that experience.
Let me take the second part. One of the things I tell people when they come to our basic mediation course is that, number one, if you take the 40 hours with the anticipation that you're going to make money or even earn some money, the probability is slim. It's a real challenge in most of the bigger communities to get that accomplished, what you're talking about. Tarrant County they've had 3 or 4 different operations over the last 30 years. And so it's in disarray at this point. But to your question on experience, I think if you can find a venue or an opportunity to do that locally, just to gain some experience, I think that could be beneficial. One of the things I know that our basic mediation training, we talk about a lot of hands-on stuff. And when we have basic now here, especially when it's here in Lubbock, I want people to have real experience. So one of the requirements is that they have to go and co-mediate an actual case before they can walk out the door. And we kind of do that throughout the year whenever we have training sessions. But Monica, I think if you go through the guardianship training in Salado, you're going to have training, but the reality is you're probably not going to have any cases right now. And I've talked to some of the past participants from the Dallas-Fort Worth area, and there's some real struggles on expanding the horizon, so to speak, with guardianship mediations, particularly because of the courts. So, and working with the bar. So I can't necessarily be on point. I mean, we'd love to have you, but I think getting your feet wet and getting some experience would be beneficial.
Okay, thank you.
Jean, if I can join in here. Good afternoon, everyone. My name is Terry Hammond. I'm the Executive Director of the Texas Guardianship Association and the Guardianship and Probate Attorney in Brazos County Courts at Law in Bryan. I had a little trouble getting signed in. For the first time, I had to sign in through Facebook. Zoom probably has all of my friends and contacts and everything now, but I am here with you. So glad to be here. Thank you for joining. Let me just kind of say also, and Gene's modified his presentation some, I'm sure he's mentioned already, because we have a smaller group to make it more interactive, but everyone needs to be, needs to zero in on the issues and the points that are important to you. I think we all know that there's an immense need for mediation and guardianship. And when I was in private practice for 26 years, even then I found that guardianship was very, very, very underutilized. And here at the courts now, since I'm working with the courts, there's not really a formal trigger for when the court's going to call in a mediator. It's just when things get to a point that the court is not the best place to resolve whatever the issues are, and it's an expense of resources and time and all, then that usually kind of puts us on a trajectory towards considering mediation. One of the ways that you can perhaps get some mediation work without necessarily going through the court process is that lots of times when I would initially meet with family members, if there was a chance for us to resolve the issues short of bringing the government into people's lives, filing for guardianship, bringing everything that's attendant to that, the attorney ad litem, maybe a guardian ad litem, the court, the investigator, all of that into these people's lives, I would say is there a possibility we might be able to informally mediate this? And if you establish a reputation of somebody who's good at guardianship, then you may be able to just work with the private bar some, perhaps even on pre-adjudication kinds of issues. And so that's another way that I think, and Roy Brantley here, who's going to be coming on the bench in Brazos County, I encourage Roy to, come in and attend these webinars and if possible, the mediation training, because it also just gives you a really good grounding and foundation in resolving disputes. And that's going to help you whether you're here at the courts or whether you're a private practitioner, attorney, a professional guardian, those kinds of things. We still have a lot of work to do to elevate consideration of mediation and guardianship proceedings. I know one of the things Gene's going to talk about today is some recent legislative changes that Texas Guardianship Association worked with Gene, a number of judges, to get some new legislation passed that gives a fairly more significant nod and prompt towards guardianship and mediation, guardianship mediation and guardianship proceedings. Gene, is that something you want to go ahead and maybe touch on next?
Yeah, I was going to, and actually I want to maybe expand a few minutes too, Terry, on the geographic diversity of Texas and big city, small city, rural versus urban. Being out here in West Texas makes you a little bit sensitive sometimes of all the people who are not out here and they're on the eastern half of the state. But I guess what I was going to talk about was that there's over 200 counties in Texas that have a population of less than 85,000. And the resources that are out there, and this is something that TGA has been campaigning for years, and lobbying to try to get courts set up for guardianship matters. But as Terry said, the rural areas and the smaller communities do not have the resources. It kind of ties in a way to Monica's point, is that that's an area that we're focusing on right now, of trying to expand the resources or services to those counties. And that would include guardianship matters, because there's just not that many mediators out in the smaller communities. We are reaching out and trying to have the judges that have multi-county jurisdiction to make the referrals to our office, since we can serve smaller communities, not just Lubbock. And so that's something that we can be talking about going forward. The other piece that happened, I want to tie this into mediation, the session, and I hadn't planned to talk about this, but in the last session, there was a bill on the consolidated filing fees that the legislature passed, signed by the governor. And the bottom line is that the consolidated fee took the opportunity for some counties, or many counties, smaller counties, took money that potentially could have gone to them is now in a central pot going to Austin, meaning that the ADR fee in Blank County may or may not have been collected $15. And if it wasn't being collected, the consolidated fee automatically created the $15 income going to the ADR fund in Austin. So rural areas are not able at this point to collect the ADR fee. And legislatively, I think it's going to be an opportunity in the next session for all of us to work on trying to get that changed, so that guardianship activities can be taking place in some of the smaller communities using that pot of money. And the other piece with that is, in the last session, the JBCC was given the authority to create a training designation or certification for guardianship mediation training to 24 hours. And we were able to get that passed, and Terry did all the work, and we worked with JBCC afterwards to develop the rules. So now that there's that process, that if somebody wants to provide guardianship mediation training, the JBCC is the certifying entity. Now, I think the significance of that is the only mediation training that is certified by a state agency. The basic mediation is not certified by anybody. Family mediation is not certified by anybody. None of the mediation training programs that are offered are certified by anybody except guardianship, which is being provided by us. No other entity has gone to the JBCC and sought that certification. So I don't know if this is going to be something that will open up the door for more certification and mediation training in general, but it's done, and it's good or it's bad. But there's some folks out there now that are promoting elder mediation. I was going to talk a little bit about this, that the elder mediation and making it synonymous with guardianship mediation. And then there is a difference between the two. So I want to make that point. I don't know if that's what you were alluding to, Terry.
Yeah. Let me give everybody the estates code section. It's 1055.151, mediation of contested guardianship proceeding. And basically the section of the code now, it's also 1055.152, basically says that in determining incapacity of the proposed ward, a determination of incapacity of the proposed ward may be an issue to be mediated, but the applicant for guardianship must still prove to the court that the proposed ward is an incapacitated person, is required by Chapter 1101 of the Estates Code. We wanted to make sure that, you know, the parties weren't able to barter away the determination of capacity and make a finding or an agreement that would somehow be binding on the court. So that finding still has to be made by the court based on the evidence presented by the applicant. All parties to the proceeding shall evaluate during the mediation alternatives to guardianship and supports and services available to the proposed ward, whether the supports and services and alternatives would be feasible to, and whether the alternatives and supports and services would be feasible to avoid the need for appointment of a guardian. So there we were able to infuse into the mediation process something that was left out in the reforms from several years ago. Supports and services and alternatives were kind of woven through the Estates Code, but it did not make it into consideration at the time of mediation. So that's in the Estates Code now. And then it goes into how the cost of mediation can be handled, whether by the county or elsewhere. And the Estates Code now also allows for JBCC to set up this 24-hour advanced course, which TGA, I think, Gene, is the only accredited or credential provider of the sanctioned mediation course, correct?
Correct.
Now that's in a separate section of the code. I'll have to find that. But that's basically a much more substantial mediation section of the code. Now, we were not able to get in the bill, or weren't able to get through the legislature that there would be a requirement of mediation in guardianship cases. Of course, that's still discretionary with the court, and often it's based on a motion by one of the parties. Sometimes you can have a proceeding get into the tens of thousands of dollars in expenses and time and significant stress and all before the idea of mediation arises. So obviously it's important to try to get that trigger as early in the proceeding as possible. Any questions on the new code section that we just brought up? I'm wondering, Gene, well, I'm going to ask Gene to talk a little bit about some of his mediation experience in guardianship proceedings, and then the advanced course that we'll have in that we'll typically do a couple of times a year. And I'll say, I think we've got in the range of about 40 mediators in the state who have taken the advanced course through the Lubbock County Dispute Resolution System and TGA. So there are not many people who have this credential, but part of what we are trying to do is kind of elevate the bar all the way across, so that people, you know, are coming in and taking advantage of this as an alternative to guardianship. Gene, let me ask you, at what junctures during a guardianship proceeding do you see mediation as being perhaps most attractive or most with the greatest possibility of having an impact?
That's a loaded question. Terry, my horizons on that, it keeps expanding. I do think, and this is me, if I had a magic wand, I probably would statutorily require that there be a mediation annually if somebody's on guardianship, in a guardianship. the potential is there for so many changes to take place in a given year. And so that's one area. But, you know, we've had some interesting experiences, and again, I just bragging, but we recently, Lubbock PD makes referrals to our office. And I had a guardian call, and she said that every time she went over to visit the ward, her mother in the nursing home, they kicked her out. And partly because she was a nurse and she didn't like the way that the facility was taking care of mom. But anyway, the PD was being called to have her removed from the property for trespassing, even though she was a guardian. And so, but the PD suggested that she call us and set something up between the players rather than keep calling them. And so we moved in that direction. But, you know, it tells me that there's stuff going on between family members and people who provide the service. And we, like you just said, it gets back into the court structure or whatever, and somebody goes and gets counsel, and the cycle just keeps on going. But if there's a way to educate law enforcement and some of the other players to utilize or suggest a mediation earlier, it might help. I don't know, but we also just had another one that the court referred to us, and this is the worst case scenario. There were approximately 18 heirs and split almost equally on both sides of the fence, so to speak. And there was a competency issue and a capacity issue, but the bottom line is that the family was squabbling over whether or not dad or mom was giving them 2% of the property each. And dad is deceased, mom was part of the mediation, and it just didn't play out the way that we wanted it to, and partly because of the virtual aspect. And this is another area that has really caused some changes, because with virtual, as a mediator, you now have a whole different set of dynamics taking place, and you can't see some of the same things that you would see. And that's one of the concerns that I do have with the smaller communities, is that we're not doing things in person, and are we losing out? So that's a long-winded answer, but I think the courts still are a push. I still see the possibility of respective attorneys that are involved asking for it. But I think if there was a push, such as the annual process, that you had to go through a mediation, that it might really help some of the relationships and some of the issues that have surfaced. I haven't been able to pull that off here locally, but that's my thought. I don't know, Terry, if that answers.
Yeah, let me ask, any other questions for Gene at this point?
Yes, I have a question. Contrary to what it says, I'm Roy Brantley. I'm not Billy Hart. I'm using his Zoom. With respect to a mediator, and when you first think that you should bring in a mediator, I'm intrigued on the alternatives or to be considered. I didn't understand that when it was said earlier, dealing with supports and services. I envisioned you've got the CME report, and you got the parties talking about the CME report. Help walk me through that. How do you get to mediate that, or you just talk about ideas? I'm kind of lost there as to what is meant by that.
Terry, did you want to?
I'll take an initial jab at it. When I think of alternatives to guardianship, I think of, I'm 65 years old, I think of Mayberry and the Andy Griffith Show. And, you know, the way that everybody just sort of helps someone else along. the old-fashioned way. And so to me, it comes down to, can you pull together enough resources in the community to where you might be able to meet a person's needs? And maybe it means bringing in a supported decision-making agreement. If you've got maybe someone with an intellectual disability who's pretty high functioning. I know we have actually terminated some guardianships when we were able to get a medical report indicating that the proposed ward had the ability to execute a supported decision-making agreement. So maybe during a mediation, if that comes up, maybe you break and see, give someone a CME, certificate of medical examination, say, get this to the doctor, see if the doctor will look at this and fill this out and say that the person can do a supported decision-making agreement, or maybe as part of the mediation settlement, you say that will be attempted before anyone moves forward with their application for guardianship. Sometimes, you've certainly got things like powers of attorney. You may have maybe an ABLE account that can be created to avoid a guardianship of the estate. There are any number of options that may be a possibility, and it may be that, whatever was hanging up the family, the 1964 Mustang that one sibling got instead of the other, and when you drill down into it, it's about that car and what happened, 50 years ago, 60 years ago, that you get through that issue, and then you begin kind of building on the resources within the family or within the community. And I have to say that a court, in my opinion, and I've worked on several thousand of these cases, a court coming into a person's life or a family's life is just about the most foreign element that can be imagined, because the court is going to be there as long as that person is alive and needs a guardian. So that means accountings, that means reports, it means the bond, it means all of that intrusion, and lots of times during the mediation,
Public record.
yeah, all this stuff on the public record. Lots of times people file for guardianships and they think they're going to waltz right in and be king of the roost. And they find out one way or the other, and it's nice if it can be done during guardianship, this isn't going to be exactly the way you want it to be. And maybe we need to draw on these strengths, because you're going to give up a lot of control to the court, to the attorneys, to other people who are involved. And so when I think of alternatives, I think of all of these options that may pull people back from the precipice, and that the court might buy off on, considering the mandate we have under the Estates Code to do something less restrictive. But that's kind of, it's a little bit, you have to back off of the fairy tale aspect of something like, Mayberry, but that is the idea, the kind of vision I have in my mind, that people are pulling together, coming together. Maybe you can get MHMR to do something that they haven't been doing. Maybe you can draw on the resources, the benefits that people should be entitled to or should be utilizing. And sometimes it means trying to negotiate out the negative influences to where you can build on the positive influences and have those alternatives that are getting stymied somehow. I mean, lots of times we've gone into guardianship because a power of attorney was done but not working right. People weren't respecting it. The proposed ward wasn't respecting it. People weren't playing by the rules. And so can you use mediation to do a reset? And there's a slim possibility that you can avoid court altogether, or maybe even whittle the guardianship down by drawing on these alternatives to guardianship. Gene, I don't know if you want to add to that.
I would like to add something on that.
Yeah.
Go ahead.
I just saw this recently on the Mayberry analogy. I'm a married man, very happily married, but I never noticed that all of the Mayberry people, Andy, Aunt B, Thelma Lou, Barney, all were married, were not married except Otis, and he was always thrown in jail for being drunk. I didn't write it, I just read it.
Well,
So
there-
sorry.
there
I
also-
saw that online too a few days ago.
Yeah.
And it
You
made me
see
wonder.
that? I'm sorry.
they're also extremely Anglo, so there are probably some other analogies we can draw on.
Yeah.
But that's sort of, let's say the Huxtable family. That is very much the same kind, who wouldn't love to be
Yeah.
in that sort of fairy tale situation?
Family.
But there are real world elements that you can draw on to improve a person's life. And, I've done a presentation on something like life, liberty, and the pursuit of happiness, how guardianship can help fulfill the American dream. And the whole idea is to use whatever resources you can pull on within the context of a guardianship to lift a person up and help them. Sometimes we've done guardianships where a person was, had $3,000 in the bank, disqualified from Medicaid benefits, and has a $60,000 nursing home bill built up. Well, maybe you can come in and use guardianship to do a strategic strike to address that kind of situation, right the ship, and then get out. You look at something like Brian Wilson of the Beach Boys, who went under guardianship after, a couple of decades of very, very severe mental illness and drug abuse. They did a guardianship on Brian Wilson for about 5 years and then terminated it. Got a trust in place, got good support for him, good therapy, good treatment, good wife, more kids they adopted. And maybe mediation can be used to just use enough of the guardianship to get things right. Use another analogy, you think of the show Quantum Leap, where they would use a little computer and kind of zero in on a situation. I remember one where this kid out on a farm was singing a song called Piggy Sue with farm animals all around, and the guy in Quantum Leap went in and said, "Why don't you try Peggy Sue?" And the kid started singing Peggy Sue with his buddy Holly, and he got to leap on to fix some other situation. So can mediation be used as kind of a quantum leap type thing to strategically impact on something and get things straightened out? Gene, I'm sorry if you were going to say something.
No. You're touching on, I think the skill of a mediator is really important. And I'm a firm believer that mediation process is a communication process. And if the door is open to communicate, you're going through different stages in order to come to possible resolutions. But as most of you know, if you've been involved in mediation and or have gone through the training, you got positions and interests that pop up in mediation. And a lot of folks get stuck on their positions. And so one of the things I like to emphasize as a mediator when I'm working with a family situation is, what are the real interests? What are the motivators? And I can give war stories on this, but I much like what Terry's talking about, I've seen two brothers arguing about stuff that happened X number of years ago. Mom loved you more than she loved me. And, so that, one, or the other example I can think of in which the brothers and sisters, all now in their 60s, remember that one of the brothers used to sneak out at night through the bathroom window to go out and have sex with people, and then mom wouldn't do anything about it. So they got into that big discussion, but that was the interest. They had to ventilate and get over that before we could even move toward working a resolution that was satisfactory to the family. So I think the skill of the mediator is critical. And one of the things we talk about is to focus on those positions and interests and not get into the legalese at the beginning, because that's where folks get entrenched and they find it hard to move off of, and they need to ventilate sometimes and get those feelings out that they've been harboring for a number of years. So that's something we do push, and ties into Barney and Buddy Holly and all those good folks around here. But we keep moving Buddy Holly's statue around Lubbock, so trying to find a better place for him. So anyway, any questions? I mean, we're just rambling here, but Melissa, you look intelligent. So you have a question?
It's misleading. No, but just a comment is I love the idea of using mediation, like to take care of things before having to even get involved in the court, to being able to resolve things, you know, possibly outside, not even having to go the court route. So that's very intriguing. I've never even considered that. So
Okay.
It requires some skill and finesse, and there have to be enough resources within the family to draw on to, you know, even have a chance of finding those common elements. But, you know, maybe 1 or 2 times out of 10, you know, I would be able to do it. Having someone you can go to and say, okay, well, this is a neutral third party. They've taken this, you know, specialized mediation training course, whatever. You know, let's save some money and some stress and some difficulty, especially, you know, when you think about the people who come before the court whose rights are being adjudicated, and they see whatever is happening among their family members, and lots of times, whether they're younger or older, they're, you know, somewhat aware of all of that. One thing related to that, Gene, I want to bring up that we've talked about before in our trainings is the role of, I know some of you are appointed as attorney ad litem or guardian ad litem, the role of an attorney ad litem or a guardian ad litem in the mediation process. Gene, I know we've focused in on some of that during the trainings. Do you want to just briefly touch on your view of how those roles should be handled in mediation?
Well, I think some of that, Terry, is going to depend on the attorney who's been appointed. But what I try to do is, as a mediator generally, is have a conversation with one or both before I even start a mediation, to find out where they are. I've had situations, haven't happened to me, but I've had situations where the guardian ad litem differed with the attorney ad litem and or objected to a direction that the mediation was going, and it caused some real problems and frictions and just entrenched everybody. So from a mediator's perspective, I try and make sure I know where they are if we do have a guardian or attorney ad litem in the process, so that they're not going to upset the apple cart down the road. And if they have a position that is just the opposite of everybody else's that's going to be in the mediation, try to address that before we even get started, because otherwise we're going to be probably going in circles.
What about also, I'm just kind of skipping on top here because of the limited time we have. What is your view, Gene, of the participation of the ward or the proposed ward, the person subject to the guardianship, proceeding, their participation in the mediation?
My preference is always to have them in the mediation, capacity or not, because otherwise, if they're not in the mediation, my thinking is that it's all secondhand information to some degree for me. And this way, and I use this illustration, but she had dementia, and but man, she had some nonverbal communications going on throughout the whole process. of the mediation. And it was almost like she understood what was happening, and I suspect she did. And but I was really leaning on her, and another one the same way. That she didn't have dementia, but hers was Alzheimer's, and there were some issues there. But she was able to communicate more than what the implications were, and so that's why I leaned that way. If at all possible, I want him in the mediation. And be in the chair, it doesn't matter, because that's my picture too. And I otherwise it's secondhand information. And not everybody's going to agree with that, but it's about them. And so let's focus on that issue and where we're going to end up going with it.
Is there anything, Gene, thank you for that. Is there anything unique to guardianship that you see or want to see in mediated settlement agreements?
Well, I've already described the annuals. I think the other thing, if I had another magic wand with the estates code, and this is not to be critical of the bench, but there's that provision in the estates code on the mediated settlement agreement can be rejected by the court. And because it may not be in the best interest of the proposed ward or the ward. Family matters, family code, the Supreme Court rendered a decision on that, and for family cases, and it stopped the court from changing the mediated settlement agreements. And that's one thing I'd like to see happen on the guardianship side too, because I can see where the subjectivity of some other players who were not in that mediation could definitely end up rejecting what everybody worked hard to come up with. And because the judge maybe didn't like it, or maybe opened the door for another discussion about it. So those are some things that I can see. I think my style of mediation is to be all inclusive with the individuals and families. So I know a lot of mediators don't like that. They want to narrow it down, but I think that from a style standpoint, it's something that I've tried to focus and hope for. I don't know if that's speaking to what you're asking about, Terry, but you're asking loaded questions, so I'm going to.
Well, all of us who survived law school, a lot of us are damaged, and when we get the chance to ask a question, we take advantage of it as much as we can. All right, guys, anyone else want to ask Gene a question? We've got about 8 or 10 minutes here left. This is your chance to ask the expert things that maybe you might not ever get to otherwise.
Rick, you keep nodding your head. You're meditating. You have any questions?
No, I wasn't nodding my head indicating that I have a question. I don't know why I nodded my head, but I have found it very interesting, and I enjoyed the comments of Buddy Holly in Lubbock, and the Quantum Leap show that used to be on NBC many years ago.
Yeah. I think that although,
Scott Bakula was the actor's name, if I remember correctly.
Scott Bakula, that's right. You're exactly
He's
right.
in NCIS New Orleans now.
I think that I view working on guardianships, and I think just about everyone here is pretty seasoned on this, as being more than just a practice, whether you're a professional guardian or an attorney. It's a privilege to work in this area and to have the opportunity to impact on someone's life, and a positive impact. But by the same token, we see situations where damage is done, and using mediation right, using it frequently, using it cost effectively is another tool that is often forgotten about or neglected. And I think our main goal and objective in this session is that it's incumbent upon us who work in this area to draw on these resources and these tools that we have. And so I encourage you, Gene is remarkably accessible. Reach out to him. If something comes along you might have a question about. Gene's an ace on ethical issues and takes mediation very, very seriously. I'm always happy to help out too. I'll add, early on when I first came here, I guess it was in 2017, we had a really contested, badly contested case, and the parties agreed to allow me to mediate it. And we went late into the evening, a couple of nights, and the court actually, and we knew that if we weren't able to mediate it, that, you know, the case would have to go to somebody else, but everyone agreed that we would give it our best shot, and it was very, very contentious. Don't hesitate to, you know, ask the court, to approach the court, to utilize the court's resources to, you know, to really prompt mediation. Lots of times, judges, especially if they are not as sophisticated, maybe you have a constitutional county judge, maybe you have somebody who guardianship's only a fraction of their workload, their docket. Don't hesitate to approach the judge on those kinds of things. Gene, any last comments that you have?
No, let me just say this. We've got a few slots left in Salado, so if you know, you might be interested, and or if somebody else who might be, get in touch with us. I'm still 60 days out, but we're pleased with the enrollment so far. But if you've got ideas that I want to tie into what Terry's talking about, for the smaller communities and the constitutional county judges, there's some things that we're going to try and be as creative as we possibly can. So if you've got an interest in that area, please let us know or let me know. And so we maybe can suck you into the process a little bit, because there's a lot of folks out there that would love to go to mediation, but just don't have the resources or the ability to access. So that's one of the good things maybe that's happened with the virtual approach.
Well, Monica Benson, if I can follow up on your question early on, you know, I know lots of times in the statutory probate courts or maybe courts in general, the judges seem to sort of have their favorite go-to mediators, you know, the ones that they, you know, have had good luck with in the past, success with, that kind of thing. But also there are opportunities. Gene is always reminding us at TGA about paying attention to the more rural parts of the state. You don't have to go very far to get to, you know, counties that only have a constitutional county court. And I would encourage people who want to do more mediation to fan out among those other counties and make contacts. And lots of times those people are really looking for help and resources, and they don't have a place to turn. That's actually how my position here in Brazos County came about, is the judges just felt like they were handling a whole lot more cases than they knew what to do with, and they didn't have help. So I'd encourage you, if you're interested in doing more mediations, to, you know, certainly we have the bulk of the cases in the metropolitan areas, but a Category 5 case can be even worse in a constitutional county court, where you don't have all the infrastructure of a statutory probate court. Then we have everything in between too. So we have Gene's information up there. You can reach me at terry@texasguardianship.org. We appreciate you joining us today. Anything else before